Good afternoon, everybody. This is Paul Singer with Kelley Drye, and welcome to this installment of our State Attorney General webinar series this month featuring the West Virginia Attorney General's Office. We're going to give folks just a minute to join the webinar, and then we will get started shortly, so stand by. All right, it looks like people have slowed down joining, so why don't we go ahead and get started. Hi again, everybody. I am Paul Singer. I am a partner and the chair of our State Attorney General practice here at Kelley Drye. I am thrilled to be joined by my colleagues this month, Donnelly McDowell, who is a partner and chair of our advertising and marketing section at Kelley Drye. And as usual for these webinars, I'm also joined by Special Counsel Abby Stempson and Associate Andrea deLorimier, who both are part of our state AG team. So welcome to this month's webinar with the West Virginia Attorney General's Office, where we're going to have a special focus on ultra-processed foods and how this kind of fits into some of the broader public health initiatives that state AGs in particular have really brought to the forefront over the past year, not just through enforcement, but also through supporting various pieces of legislation that have been coming up in different states. And right at the forefront of that, I would say, is West Virginia. And so this is an incredibly timely conversation to be had today. And we're thrilled to be joined by several members of the West Virginia Attorney General's Office today. Jace Goins, the Chief Deputy in West Virginia, Haight, who is the director of the Consumer Protection section, and Abby Cunningham, who is an AAG in the Consumer Protection section. So thank you all for being part of today's webinar. Before we get started today, there's a few housekeeping items that I need to go over. First, if you are seeking CLE credit for today's webinar, it will be provided. There will be an attestation form that you will receive at the end of this webinar. On that form, there will be a space for a 4-digit code. I will be providing that code towards the end of today's webinar, so please stay tuned for that code. I will read it twice, but we will not provide it in writing, so please make note of it so you can make sure to get credit. Second, if you have questions today, you will see on the bottom of your screen, most likely, is a bar that includes a Q&A button. If you have a question, please use that Q&A feature. We will be monitoring those throughout the webinar today and try to get to any questions that you have. In the event that we're unable to reach to any of your questions or answer any specific questions, we will be following up this webinar with a blog post and a recording of today's session. And so we can always provide information after the fact. And as always, you're free to reach out to any of us on the Kelley Drye team for further follow-up. So with that, why don't we take a quick look at our agenda real quick on the agenda for today. So we are going to cover we're going to have some opening remarks from Jace, assuming we can get his audio straightened out here. If you've joined our webinars in the past, you know we like to do a quick lightning round session just as an overview.
Not sure why this isn't working.
We'll do an overview of the laws in West Virginia, and then we'll turn to our topic for today, where we're going to focus on ultra-processed foods. So with that, I think, why don't we go ahead and move to the lightning round while we're trying to get Jace's audio straightened out, and then we can come back to Jace if we're able to do that. So why don't we start with some of these quick questions, and Anne, I think you're going to take most of these, but maybe you can start and tell us how the AG is selected in West Virginia.
Okay, the Attorney General is elected for 4-year terms, and Attorney General McCuskey has just finished his first year in office. He's got 3 more years.
Great. And how is consumer protection organized in your office?
We are combined with Antitrust, so it's the Consumer Protection and Antitrust Division. We have a small but strong office. We have locations in Charleston, which is the central part of the state, and in Martinsburg, which is the eastern panhandle. And we also handle the consumer complaint processes.
And how do you set consumer protection priorities in the office?
Well, we look at a number of different things. Some may come from our main office of things that they are aware of or that the Attorney General has special interest in. We also look at consumer complaints that come through our office, and we look at newspaper articles, magazine articles, things that may be new and of interest, and then evaluate which ones we're going to pursue.
And do you participate in multi-state investigations?
Yes, we do. It especially is helpful because we're a smaller state and that gives us resources that we wouldn't normally have. So, yes, we do.
And I'll combine these next two questions. Do you receive consumer complaints, and then do you do any sort of informal or formal resolution with those complaints?
Yes, we do receive consumer complaints, and we have a non-attorney mediation process where they are, and it's a voluntary process that we reach out to businesses and see if they would resolve those particular complaints. If they don't, or sometimes we have some that don't respond, it will be reviewed by an attorney, and the attorney may try to mediate or may decide that we need to take it further for investigations or litigations. But we start first with that voluntary mediation process.
Great. So I will hand it off to Abby for more questions.
All right. Hello, Ann. Let's keep going. What is your primary consumer protection statute in West Virginia?
It's going to be West Virginia Code 46A-1-et cetera, which is the West Virginia Consumer Credit and Protection Act.
And are you able to conduct pre-suit investigations by statute?
Yes, we are.
Can you request documents?
We can. We use investigative subpoenas. And we also, if I can anticipate, we can also take statements from people. We can send interrogatories. We can have informal or formal statements under oath to decide what we're going to do in the investigation or after the investigation.
And CIDs, are they confidential?
Well, it's an interesting question because investigations are confidential and anyone that we're investigating is confidential, but not necessarily is there anything that says that the subpoenas or responses are. However, we've not run into that issue at this point, knock on wood, but we would treat it all as anything being released would identify who we're investigating, so we wouldn't be allowed to disclose it.
Okay. Does your law allow a party to object or set aside a CID?
No, it doesn't, but we usually end up in discussions with the business on what they're willing to do or not and what we need or modify until we may have to go to enforcement. But we will work with businesses to figure out what they have and what we need.
Okay, and you mentioned enforcement. Can you enforce compliance?
Yes, we can. We bring an action in our circuit court, which is our trial court, to enforce the subpoena. And at that point, the existence of the subpoena and the business does become public.
And do you have a statute of limitations? And if yes, what is that time frame?
Well, we have a statute of limitations only for civil penalties, which is 4 years. We do not have a statute of limitations for restitution, disgorgement, or other equitable relief. But so it just limits the civil penalties. But we also do have the discovery rule here and continuing violations, which may extend that 4-year time period.
Okay. Now, do you have to provide pre-suit notice? And if the answer is yes, in what time frame?
We do for subpoena enforcement, and it is a quote unquote reasonable notice. But otherwise, we don't have any requirement to when we're going to file a civil suit, although normally we've been in discussions with the business and they're aware of our next step.
Okay. Okay, let's go on to the next page. What types of settlements can you enter into?
We can enter into what we call an assurance of discontinuance, which some states call AVCs, or we can do settlement agreements, or we can do consent judgments.
And so you already mentioned civil penalties. What is your civil penalty authority?
Okay. If a defendant shows a course of repeated and willful violations, a court can award penalties of up to $5,000 per violation.
And can you get restitution, assuming the answer is yes, based on you mentioning it earlier?
Yes, we can.
And disgorgement?
Yes. Any equitable remedies or other appropriate relief is what we can recover.
Okay. And are there ever times you don't get injunctive relief or you don't get penalties or a payment?
Depending on the facts and evidence and the particular judge that we may have, we have seen judges who will not award certain things because they think it's too harsh, whether it's an injunction or a civil penalty, or if there's an indication that more with individuals than businesses, but if they don't have resources. And some don't like the up to 5,000 and they'll pick their own number.
Got it. How are your IR terms enforced? And what if they are in an ABC?
Okay. We'll enforce any of them through a circuit court enforcement, whether it's a violation of an assurance of discontinuance or the settlement agreement. Obviously, if it's a consent judgment, we've already got an appearance before the court and we'd go in to enforce that judgment.
All right. Price gouging. Do you have specific laws and remedies specific to that?
Yes, we do. With an exception for a state of preparedness, the governor or legislature has to designate which parts of the price gouging statute would apply to what goods or what services.
And how about auto renewals? Do you have a specific law or remedy for that?
Not yet, but it has been introduced in the last couple of years, and our legislature is currently in their 60-day session, so it could happen again.
Okay. How about a privacy law? Do you have one?
It's been introduced for this legislative session, so not officially yet. We do have a data breach notice statute, but not privacy law yet.
All right. So you mentioned a few that were introduced. My last thing is any new noteworthy CP laws. As everyone on this knows, we're going to talk about a very noteworthy one. So how about we skip that? Jace is on. Jace, can we hear you? Do you want to say something?
Yeah, I think you can hear me. Can everybody hear me okay? I can hear everybody okay. I think y'all could hear me. I just couldn't hear you. I had a little technical issue with my speakers, but I'm good now. Thank you.
Excellent. So I will pass it to you, Jace, to talk about consumer protection in West Virginia.
Yeah, I think in terms of getting into the more granular issues, I will leave that to Ann and Abby, our consumer protection specialists. But can everybody hear me okay? Okay. I see Ann kind of leaning in like she's trying to hear me. But yeah, I think, we have a new Attorney General, J.B. McCuskey, who came in January. JB is very focused on consumer protection. It's something that is important to him. We've sort of been on the offensive with, for example, pharmacy benefit managers, which is a matter of public record that we have brought suit against a couple of the PBMs regarding their involvement in the opioid epidemic. We are also looking at a lot of other areas in tech and obviously ultra-processed foods. Can't get into too many details because those investigations are confidential, but I think it's something that RAG is focused on, very focused on consumer protection. We've been working with a lot of other AGs and consumer chiefs in other states. There is a good network of communication amongst the various states regarding these consumer protection initiatives. So certainly I think it's something that we'll see more of in the future. And I think the feeling is among the state AGs that we are a bit more nimble, if you will, in terms of consumer protection as opposed to at the federal level, either Congress or federal agencies, which are a little more, maybe a little more slow moving than some of the AGs. The AGs can do things more quickly, take action more quickly. In a lot of cases, of course, we do work hand in hand with federal regulators on these issues as well, but I think it's something that we're going to be focused on throughout our AG's administration, and it's certainly a big issue with us.
Well, thank
That's,
you, Jace. Paul, passing it to you.
yeah, I was just going to say the same. I mean, thank you for that helpful overview. And I think it is sort of a nice segue into our topic of the day, which is to really focus in on one of those initiatives that you just talked about, Jace, which is really to talk about ultra processed foods, and in particular legislation that y'all have had in West Virginia, and then I think, as that sort of highlights, and as you talked about, how that kind of bleeds into enforcement priorities for the state as a whole. So with that, I think we will pass it to Abby Cunningham to talk about UPFs and the state of things in West Virginia.
Yeah, thank you, Paul. So again, I'm Abby, Assistant AG in the Consumer Protection Division. I am so glad to be here today to discuss West Virginia's recent legislation banning 7 harmful synthetic food dyes and 2 harmful preservatives, and that's West Virginia House Bill 2354. This law and others about food, others like it about food, are an important new trend. It's very interesting. They kind of form a bridge between public health and consumer protection. And so today we're going to take a look at why we're seeing laws like this and how we might use it in a consumer protection action. So as you can see, our agenda's up here. We're going to very briefly go over the states that have recent laws concerning ultra-processed foods, define and learn how to identify what ultra-processed foods are, because it's not as easy as you might think. Go over the context and timing, the reasons why we're seeing this legislative activity, look at the text of West Virginia's law, and then finally round it out with implications for consumer protection and enforcement. There's a lot to do, but we're going to do it. We're gonna do all of this, and it's going to be great. All right, let's move to the next slide. Recent laws, and one more click. Okay, so West Virginia is not the only state to pass legislation in this space. In fact, all the states on this list, and some more, have passed law in the last year or so related to ultra-processed foods, additives, or food dyes. Some of the statutes address school nutrition programs. Some have additional labeling requirements. I really wish we could go over all of them, but we can't. We're just going to be looking at West Virginia's law in more detail today. If you could click through to the animations. There you go. House Bill 2354 from the 2025 legislative session. It does bear mentioning that some of the statutes in these states are being challenged, including West Virginia's law, but we know that sometimes happens. For our purposes, we're going to assume that the West Virginia law stays in effect as written. All right, so let's move to the next item in our agenda. Let's stay on this slide for a minute, because before we get to defining what ultra-processed foods are, we should take a step back and talk about food processing generally. So processing itself isn't controversial. It's not a bad word. Nearly everything we eat is processed in some way. What matters is how much processing occurs and why. So historically, processing was about preservation and increasing access to safe food. So drying and smoking, meats, canning, pasteurizing, things like that. But in the 20th century, mid-20th century, post-World War II, the focus shifted away from preserving foods or food ingredients to engineering finished food products. And this intensified over time. And these products became increasingly made from extracted or refined components that were optimized for industrial use. chemical additives, colors, custom designed flavor compounds. So food started to look less like something that was prepared and more like something that was built. And this is why we end up with a term like ultra processed. It reflects that processing exists on a spectrum and that some foods are processed to a fundamentally different degree. The real question is where to draw those lines. So now we can move forward to the next slide. Here's the problem. There is no uniform definition of ultra processed foods. So different groups from academia, public health, government all have slightly different ideas about how to define these foods. This is just a small list. I'm sure you could find many others with different takes on exactly what ultra processed means. The first one on the list, though, is important because that's where we got the term ultra processed. That was from the NOVA classification system that was developed in 2009 by a Brazilian scientist looking at what buckets we can put food into to describe how they're made. So again, all of these definitions are a little bit different, but there are some common threads. So rather than looking at one perfect definition, it's probably more useful to look at what they have in common. So let's move forward on that. All right, so we do see some consistent themes and elements in the various definitions of ultra-processed foods. And as we go through this, you might notice or think of ways that some of these themes may overlap with each other. Okay, so one pretty consistent theme is that ultra-processed foods use industrially manufactured ingredients not found in home cooking. So for example, synthetic antioxidants like tertiary butyl hydroquinone. I don't have that in my pantry. Ultra-processed foods also contain additives with cosmetic purposes or specific functional purposes. So this is where your bright food dyes come in and texture additives like emulsifiers. Another theme is that ultra-processed foods can be formulated from extracted or refined substances rather than whole foods. So here we're talking about refined sugars and starches that improve flavor and texture and shelf life, but deliver empty calories because they're separated from the natural food matrix. Yet another theme is that ultra-processed foods often undergo extensive transformative industrial processing. So example, extrusion, using high heat and pressure on a starch slurry before it's pushed through a die to create your favorite colorful O-shaped breakfast cereal. And the penultimate theme, ultra-processed foods can contain high amounts of calories and also added salt, sugar, or fat. And lastly, ultra-processed foods are often designed for convenience, shelf stability, palatability, and profitability. So prepackaged marketing, often targeting kids with cartoon characters, made from cheap ingredients, custom designed to appeal to the hedonic reward system, immediate sensory gratification. They're designed to taste and feel so good that you're more likely to keep eating even when you're not hungry. So it does bear mentioning that a food product doesn't need to check every box to be considered ultra-processed, but it's probably going to have one or two of them. So let's move forward to the next slide to get a visual, right? Okay, so here's food processing as a spectrum, right? It's not a yes or no label. Again, almost everything we eat is processed in some way, and it's going to fall somewhere on the spectrum. So on the far left, you see the least processed foods. These are foods that remain closest to their natural form, even though some basic processing has happened. So washing, cutting, butchering. T-bone steaks don't come straight from nature in that form. Some processing has to happen to get it to the point where you can put it on a grill, but it is essentially still an individual single food. So as we move towards the middle, processing increases. Processing can help make basic culinary ingredients like oils, spices, butter. And then further along towards the right are foods like fresh or homemade bread, cheese, canned foods. These are all foods that are made from recognizable ingredients using familiar traditional industrial or traditional processing methods and are clearly still identifiable as food. And then we go to the far right. If we could click through to the animation, this is where you're going to find most of your ultra processed foods right there. This is usually going to be a you know it when you see it scenario. You're generally looking for things that are finished foods, mass produced, shelf stable, attractively packaged, but maybe the biggest tell is a long ingredient list that has a bunch of hard to pronounce substances on it. These aren't just more processed versions of the food on the left. They are fundamentally different due to the complex industrial techniques and engineered ingredient mixtures we talked about briefly a minute ago. The final product often no longer resembles a whole food. But before we move forward, it is important to keep in mind that while you're able to use the you know it when you see it method to identify most ultra processed foods, reading the label is still important for things that you might not think are ultra processed. So for example, sometimes there's additives that can be found in bacon, in cheeses. Sometimes they have emulsifiers. Even moving further to the left, some oils have TBHQ, which is a preservative, a synthetic preservative that's derived from petroleum. So you really do need to look at the label. Okay. All
Abby,
right.
can I chime in just with a question we have from the audience and maybe just a follow-up?
Of course.
I know we're covering a lot, so I all good if you can't go into detail. But one question we have is whether the legal team consults with nutrition and health professionals as you're looking at these issues, and if they're, part of the office, or whether you're consulting outside experts and how you go about that.
Well, I can say just generally that that's something that we would do to consult the experts. I know more now than I did many months ago, but it's valuable to consult people with expertise in that field. And that's always something that we would do in any case, including this one.
And then thanks for that. So just, we've got a lot of folks in the audience from different industries, I think across the board in the graphic you just showed. I wonder if, as putting yourselves in their shoes, is there guidance that you would offer, or that, the state plans to offer as far as, how to approach these issues? Like you mentioned, looking at the labeling and looking at certain ingredients, certainly starting there. But are there other things that you feel like industry should be doing from your perspective, as far as thinking about these issues?
Yeah. So, as far as there's a couple questions in there, as far as like written guidance, I don't think we're there yet because, and we'll go over the statute, but it doesn't go into effect, part of it, until 2028. So we've got a little time before that happens. But as far as guidance for industry, take a good look at the additives and substances that are going into your food and whether there are possible health risks. And from my perspective, it doesn't really matter if the FDA says it's generally recognized as safe. If it's not, that's a problem. Think of ways to make your packaging less misleading. So, for example, if you have banana flavored oatmeal that has no bananas in it at all, maybe you shouldn't put a banana on the front of the package. Things like that. And last, for international companies, there are substances that are banned in Europe or put restrictions on, certain food substances. If you're using substances in America that are banned in Europe, ask yourself why and maybe rethink that. If your formula works in Europe without a banned substance, could you use it here? So that's off the top of my head what I can think of for now.
And I just want to piggyback on this because, Abby, I think you said a couple of important points that are great guidance for the audience, but in particular, we've talked about sort of the rise of legislation. And you talked about all these states that are passing it, but even those states without legislation, particular to any category of UPFs or other type of public health initiatives, still have their general unfair or deceptive trade practice authority to rely on. And so when you talk about things like packaging in particular, we've seen states like, Mild Office in Texas pursuing cases under a UDAP theory where they are focused on the types of representations that are being made about the underlying products on the packaging. And so that's just sort of like an obvious area that I think it's just important to keep in mind generally, but in particular when it comes to these types of issues.
Right. That's exactly right. Did I answer your question? Was that good?
Yeah. Yep.
Okay. All right. So why are we seeing state legislation around ultra processed foods? So there's a couple of things that are going on. Let's move to the next slide. So really, it starts with this: the rise in prevalence of unhealthy conditions like type 2 diabetes, obesity, heart disease, even childhood obesity led to a growing interest in how diet and food ingredients play a role in negative health outcomes. A very, very troubling and sad statistic is that 60% of Americans now have at least one chronic disease. This increase in chronic diseases has helped to change the economic landscape of our country by increasing demand for healthcare services. So let's move to the next slide, which is a helpful map, so we can get a little more perspective. So in 1990, manufacturing was the dominant industry. But in stark contrast, healthcare was the dominant industry in 38 states as of 2024, according to New York Times review of Census Bureau statistics. And these chronic diseases that are causing this rise in healthcare dominance, they're very expensive. According to the CDC, the overwhelming majority of the annual approximate $5 trillion healthcare expenditure is attributed to managing and treating chronic diseases. This isn't to say that ultra-processed food is the only reason for the change in how this map looks. There are numerous factors at play, multifactorial, but food and diet certainly play a role in health. But let's skip to the next one. So diet and nutrition have always been things that scientists and people in public health have looked at. That's why we ended up with the Federal Pure Food and Drugs Act in 1906, signed by Teddy Roosevelt. But these more recent shifts in health outcomes prompted researchers and scientists to look at this issue with greater scrutiny, especially in the last 20 to 25 years. And what has been observed is that the increase of chronic health issues follows the same arc as increased consumption of ultra-processed foods. And it's actually more than just increased consumptions for the United States. Ultra-processed foods now make up the majority of the average American's diet. So as far as specific health concerns go, so looking at UPFs generally, what researchers found is that increased consumption can be linked to increased caloric intake, leading to weight gain and obesity and all those attendant risks like type 2 diabetes, cardiovascular events, and even all-cause mortality. And they see this occurring in even younger and younger demographics. If we narrow our focus to petroleum-based food dyes, so looking at those food dyes specifically, studies have linked the dyes to health concerns like allergic reaction, cancer risks, negative impacts on the gut microbiome, and neurodevelopmental effects in children, leading to hyperactivity and irritability. So I do need to mention that these harms, a lot of these harms, have been known for a long time, some for over 40 years. All right, and finally moving over, studies covering preservatives indicated similar harms as the dyes, like allergic reactions and cancer risk, also asthma, systemic inflammation, negative impacts on hormone signaling, endocrine disruption, where a substance mimics or even blocks hormones like testosterone, estrogen, which can lead to reproductive harms. And as with food dyes, the harms of some of these have been known for a very long time. So these concerns led governments around the world to place bans or restrictions, but we haven't seen the same level of action from the federal government here. And that's why states are starting to take action through legislation to advance public health, make America healthy again, if you will, by preventing consumers from being exposed to these harmful additives. Okay, so now we have a better idea of what ultra-processed foods are and the context for why we're seeing these kinds of laws. Now let's look at the actual text of the bill. Okay, and if we can move to the next slide. Okay, so HB 2354 was signed into law on March 24th, 2025. This law modifies two areas of statutory code. The first being adding a new section to the state education code relating to school nutrition programs. So effective August 1st, 2025, the 7 synthetic dyes listed here were prohibited from being used in school nutrition programs. All 7 of these dyes are petroleum-based. All 7 have appeared on FDA's list of approved color additives, but the authorization for the use of red number 3 was revoked by FDA last year. And there's been open discussion about revoking authorization for the rest. These 7 synthetic dyes aren't just in food. They're sometimes used in cosmetics, household cleaning products like your favorite blue dish soap. So even though they may not be used in food anymore, we will still see them. All right, let's move to the next slide. All right, the second statutory section modified by this law is West Virginia's version of the Pure Food and Drugs Act. So effective January 1, 2028, just about 2 years from now, there's a statewide ban on the manufacture or sale of food containing the same 7 harmful dyes we saw in the previous slide, plus 2 preservatives, butylated hydroxyanisole and propylparaben. So butylated hydroxyanisole, or BHA, is a petroleum-based antioxidant and preservative, and it prevents fats from going rancid, which extends shelf life. Propylparaben is used as an antimicrobial, which also helps to extend shelf life. Propylparaben is not petroleum-based, but it is synthetically manufactured. And neither of these preservatives are approved by the FDA as an additive. Instead, they've been used by industry under the generally recognized as safe exception, which could be a whole separate webinar all by itself. So we'll put that in your minds for now. So as with the food dyes, banning these substances probably won't make them totally disappear from our lives. BHA is sometimes used in the manufacture of rubber products, like tires for your car, and some plastics. Propylparaben is also used in cosmetics, lotions, and some household products as well. All right, so let's move to the next one to look at penalties. So what happens if a business violates this law? Penalties businesses can face for noncompliance include fines, imprisonment up to 1 year, that's a misdemeanor, payment of costs for analysis of the food, and forfeiture and destruction of the food. And these fines and penalties listed here fall under the authority of the state health department. There are some exceptions. The law doesn't apply to individuals who sell less than $5,000 worth of food containing the additives per month. And also relating to schools, schools can still sell food containing banned additives during fundraising events, provided after school and off school grounds. And before we move on to talk about our last item on the agenda, I do need to mention that what we're talking about here is food generally, not food that is sold in grocery stores versus food that is sold in restaurants. The Pure Food and Drugs Act applies to food, all of it that is sold. So that's something important to keep in mind. Okay.
Just one other question there, Abby.
Sure.
How is the state kind of thinking about responsibility or liability, like as between manufacturers who create food that might end up in West Virginia versus retailers or restaurants that, sell food directly?
Well, anyone who's in the distribution chain could potentially face liability because and we'll go over the statute in a minute, but trade or commerce is where our universe is for consumer protection. So that can include your distributor, it can include your manufacturer, or your seller. It just kind of depends on the facts, but nothing's off the table.
One other question, Abby, we got that I think I know the answer to, but I'm going to ask it anyways because it was in the chat. The $500 per violation, is that per
Yeah.
item sold potentially, or how do you look at that from a violation perspective?
Well, so this specific fine, that's going to be under the authority of the State Department of Health. So that's going to be how they define it. We define violations for counting civil penalties in different ways and depending on what information we have. So, you know, I can't necessarily give you an answer on that today.
Sure.
Okay. So are there any other? Okay, we can move forward. All right. So we have gone over how to spot ultra processed foods in the wild, why we should care about them, and what HB 2354 says. So let's look now at the implications for our new law. So let's move forward one slide. So just building off of Ann's remarks from earlier, here's just a little snapshot about the West Virginia Consumer Credit and Protection Act. Its purpose is to protect the public and foster fair and honest competition, and is designed to complement the federal body of consumer protection law. The kind of conduct regulated is unfair methods of competition or unfair and deceptive acts or practices in the conduct of any trade or commerce, and it applies to advertising, selling, or distributing any goods or services, even in indirect commerce. So you heard me emphasize the word any, and that's because it's a very important term in the context of our statute. Any means just that, any. It is a statute of general applicability, meaning it's not tied to one industry or one type of good or service. So you may be thinking, wait, what if an industry is regulated separately? Well, any trade or commerce includes the activities of regulated industries. Let's move forward one slide. So absent express, field, or conflict preemption, the mere existence of a state or federal code regulating some aspect of an entity's conduct in trade or commerce doesn't grant immunity from general statutes like the Consumer Protection Act. And in fact, as Jace mentioned, our office has maintained actions and is currently maintaining actions against defendants in heavily regulated industries, opioid manufacturers, and people in the opioid supply chain. We've also had suits against credit reporting agencies, which are regulated by the FTC. I will represent to you that HB 2354 does not create a preemption issue here. We could do another webinar on that too, but as a shortcut, I'm just going to refer you to a recent publication from Harvard Law School's Food Law and Policy Clinic, and it's titled State Regulation of Food Additives and Chemicals. It was just published in December 2025. Okay, so back to regulated industries. How can we get an action against a regulated entity? So these industries will have statutes or regulations designed to protect the public in some specific way. They create express standards of care. So when a violation of those standards of care impacts consumers, we can use the statutes or regulations to help prove deception or unfairness because it resolves certain factual issues. All right, let's click forward so we can show what House Bill 2354's standard of care is. It establishes that certain substances are unsafe or harmful, and the unsafe or harmful substances are illegal to use in food. That's basically it. So let's move forward one more so we can talk about how to apply it. So a couple of things to keep in mind. First, unfairness and deception are distinct and have separate standards of proof, but depending on the facts, an act can be deceptive, unfair, or both. Second, every state's consumer protection statute will operate a little bit differently. West Virginia's law is very broad. Other states' laws are limited, so check your local listings. We're going to just go over some general concepts that maybe will help you have some good takeaways. All right, so generally, to prove conduct was deceptive, you have to have a representation, omission, or practice that is material in that it will influence a consumer's decision and likely to mislead a reasonable consumer. So you're asking, what does an ordinary consumer walk away believing? Looking at unfair conduct, you have to show a substantial consumer injury like economic harm, health risk, safety exposure, and the injury is not reasonably avoidable. And the consumer's injury is not outweighed by countervailing benefits to consumers or the market. All right, so let's look at where the standard of care set by HB 2354 can be plugged in to establish some of these consumer protection claim elements. And let's say it's a hypothetical scenario. A food manufacturer puts products on the market containing all of the banned substances. Let's just do all of them. So right off the bat for deception, you already have a representation. So by putting food on the market, a manufacturer is impliedly representing that the product is legal and safe. This has always been the responsibility of food manufacturers and marketers to put out safe products. That's before anyone ever thought of passing a state level ultra processed food law. So you already get to start there. Let's go next to materiality. So the fact that these substances were specifically banned for health and safety reasons helps to establish this. So whether a product is legal is a significant consideration for consumers. People generally don't want to buy illegal food. And people certainly don't want to buy food that might harm them. All right, and then the last bullet here, likelihood to mislead. So if consumers see something on the shelf, they're going to walk away believing it's legal and safe. They have little choice but to trust that food manufacturers are following the law. So putting a product on the market with illegal and unsafe ingredients, it misleads consumers. Looking at unfairness, just candidly, the law is probably a little bit more helpful here. HB 2354 removes the question about substantial injury. The law affirmatively establishes that the banned substances are harmful and a safety risk. So we don't even have to argue about whether there is a health risk or a safety exposure. The statute says there is. All right, not reasonably avoidable. So the law is very helpful here because if the banned substance is being used but not disclosed on the label, no consumer in the world is going to stand in the grocery store aisle and test every food before they eat it. They have to trust the manufacturers. And even if the use is disclosed, your average consumer is not going to have enough information about these chemicals to know their function, their potential health impacts. So there's information asymmetry. Consumers, once again, have to trust food manufacturers to do the right thing because the food manufacturers are the experts. All right, and then the last bullet, the law establishes that the injury is not outweighed by countervailing benefits. So the statute establishes that food with these substances is unsafe. There's no benefit to commerce or consumers by selling food to consumers that may harm them. It just doesn't exist. And also using banned substances could be detrimental to competition, so harm to the market generally. Let's say a company uses all these brightly colored food dyes to make their product look more visually appealing, which may help it sell better than their competitor's product. So the company that's violating the law then has an unfair advantage over other companies that are following the law. Okay, so let's go to the next slide, and it's probably a good simplified view of what we're talking about, this mathematical formula. So you start with a violation of a public protection statute plus conduct in trade or commerce equals actionable, unfair, or deceptive act or practice. That's very, very simplistic, but that's really what we're talking about here. And if we can do one click and we'll see this is the big takeaway. Violations of laws enacted to protect the public when committed in the course of trade or commerce constitute actionable, unfair, or deceptive acts or practices. You will sometimes see versions very close to that in some of the lawsuits that we file. And again, that, especially says how this concept can be applied in the context of ultra-processed food, many other kinds of consumer protection actions for other industries. All right, so next slide is our second to last slide. It's just a recap. So what HB 2354 is creating for us is express standards of care for industry, fines and penalties for violation, but also predicates for unfair and deceptive act or practices claims. And it removes or lessens burden to prove certain facts because the statute establishes them. So what HB 2354 is doing is resolving the dispute about whether these specific substances are safe. And through that, it's doing two things. It's advancing public health by preventing exposure to specific harmful substances. And it's also creating express standards of care that make my job easier. So, and the last slide is just some additional resources that you might want to check out. I included in here the Nutrinet Santé study. That is a fabulous epidemiological study to look at. It's the largest one in the world. It's been going on since 2009 and it has 170,000 active participants. So if you want to just kind of get an overview of where these trends are going with health, dietary patterns, consumption of ultra-processed foods, that's a good one to look at. Well, I hope this has been helpful. So happy to take any questions that you think you have.
Super helpful, Abby. We appreciate you all taking the time. Obviously a super hot issue. I guess one question, we've gotten a few different versions of different questions in the chat, and I think they relate to some of the things we were talking about in prep for this panel. Thinking about coordination with other states, you started by pointing out that a number of other states have either passed or considered legislation. Like, what guidance do you have for industry as they're thinking about, your law versus Texas's law versus California's law, and what level of coordination can you comment on as far as, with some of your other peer states?
Right. So there are different kinds of ways that states are approaching this, but it's somewhat universal. This is something where red and blue states are pretty much aligned, doing something about these foods that can cause harm. But what I see the most common theme between all of these laws is their focus on additives. So especially the chemical additives that have been developed in the last 60 to 70 years. My personal advice to industry would be, take a hard look at those. Do you really need to use all of these? Because that's where people are concerned about. They're in addition to some other things, but if you look at these laws, that's what's in them. They're talking about additives. Anything else?
So this is kind of a question and I guess more of an observation based on some of what you said, but I'm curious, Abby and others, if y'all would agree with sort of my assessment of this. I guess I'd say sort of two big takeaways I had of this, right? Is that even if you are, in an industry that may dispute perhaps some particular additive and, findings of whether or not that additive is harmful as opposed to others, right? I think one of the important aspects that I took away from what you were saying, Abby, is that, like, in the face of having a law passed that declares that additive illegal, right, in the state, that is now a pathway to not just enforcing that underlying statute, but also a UDAP violation that candidly may not really hinge on whether or not whatever sort of the arguments behind underlying science might be, right? Because now there is this finding from the legislature. And so in some ways it's like there can be conceptual disagreements about some of the underlying science, which really needs to happen at the legislative stage because you're in a position where you are enforcing the law, right? And the law in the state and what's declared unlawful by the legislature. And so that to me is just, it's a nuance that I think is important to understand that, when it reaches that stage, there is a responsibility that falls on the enforcer to ensure that the laws that the legislature has passed and acts that they've declared are illegal are going to be actually enforced at the end of the day by the office. And so, I do think that is an important aspect to keep in mind. The other thing I would observe, and obviously there's broad exposure and liability under laws like this, as you mentioned, downstream, but certainly my historical view is that I've never seen states sort of looking to play gotcha, right? It's not the situation where if you are someone downstream in the chain of commerce here and don't have control or even knowledge underlying of what, additives might be in a particular product, not to say that they're going to get sort of a free pass at the end of the day, but I think that does come into play, right, when you're considering sort of enforcement priorities. So those, like I said, these are kind of statements and observations. I'm curious if you sort of have reactions or agree or disagree with anything that I just said.
So your first comment, I generally agree. And like a lot of people want to argue about whether these food dyes are safe or not. That has been established that they're not. So, we don't have to argue about that anymore. That's what that statute does. As far as the second part of it, the downstream or upstream liability, it's really going to depend on the facts. It's going to depend on who knew what and whether whether this was just overlooked and hope no one notices, and who knew and all of that, or if it was just a genuine mistake. But it doesn't really matter if it's who it is on the chain. What matters is the facts and why we think we should be going after them as a potential bad actor.
Well, thank you for that. I know we have hit time. Obviously, as we had said at the outset, this is a highly popular topic and is one that I think the conversations will be continuing, right? Because as we continue to see legislation press forward, as we continue to see different enforcement emerge, I think we'll all start to crystallize around sort of what the rules of the road are going forward for everybody. And so, I just want to personally thank all of you for participating today. Thank you again very much to everybody that attended. Thank you to our speakers from West Virginia today. Quick plug that if you are not subscribed to our Attorney General newsletter, you can subscribe to AG Chronicles, where we provide updates on state AG activity throughout the country. There's a link there. You can also click on our Linktree QR code here to get access to all of our general consumer protection, advertising, privacy updates from the firm. So thank you all who attended. Thank you to our speakers from West Virginia. Thank you to my colleagues. And with that, we will close out today's webinar.
Thanks, everybody.